Yeah, Robert. All right, let's if we're trying not to think the world is crumbling around us, I'm told by some people, Viva, you're being dramatic. It's only because you live and breathe this stuff day in and day out that you think it's more serious than it is. It's not a big deal that a former president has been indicted. No one's above the law. And Hunter Biden, I'm sure, is saying that as he points his ill-gotten gun at a camera while smoking hard drugs. There's no downplaying that a Rubicon has been crossed here, Robert. Like, they've indicted a former president on what was at best, even if a misdemeanor charge bumped up to a felony. I don't understand exactly how they did that. That was committed. It's a decade ago, if it was committed. And even if it was committed, was never a crime in the first place. So they have to find the crime of falsifying business records to cover up this hush payment, which itself would never have been illegal. Whereas when Hillary Clinton fudged up, covered up, lied about funding the Steele dossier to leak it to the FBI to then go get unlawful spy. Oh, she paid $8,000 and the DNC paid $135. Trump indicted. Have we crossed a Rubicon? Is it possible to get too outraged over this insanity?
Yeah, I'll be discussing the geopolitical fallout from this with the Duran 2 p.m. Eastern on Friday. We'll be doing a deep dive on what this means for the geopolitical side of the equation. From the legal side of the question, it is no question it's historically unprecedented. And the issue has always been constitutionally, what are the limits on state prosecutors or federal prosecutors, for that matter, when it concerns either a former president, current president, or leading presidential candidate. And it's an unresolved issue because nobody has ever indicted a sitting president. No one has ever indicted a former president, and no one has ever indicted a leading presidential candidate before. It's never happened. And the reason is that they didn't want to test the limits of state power in this respect. That was part of the reasons. The additional reason is they respected that it simply looks very bad for one party to be indicting the other party's leading candidate for the presidency. And in fact, it is a common criticism leveled by the State Department of the United States against foreign governments when they do that. The movie that won Best Documentary was about Navalny, who Navalny is like the Lyndon LaRouche of Russia. He was never a leading candidate for anything. But it won Best Oscar under the pretext that it was terrible that he was ever indicted, even though he was not a former prime minister, never a leading candidate to be prime minister or to be president in Russia. And yet we condemned and issued sanctions against Russia for that. And now we're doing far worse. So the first question constitutionally is, what are the limits? That will be tested in this case. Should the case be stayed pending a potential the resolution of the election, and if until someone is outside the White House? The problem is this: if a local prosecutor can remove their leading party opponent for the presidency through the exercise of their criminal power, prosecutorial power, then this opens the door to ways that it effectively prevents meaningful elections. It effectively prevents someone from exercising presidential power if duly elected, because the indictment cannot constitutionally remove Trump's name from the ballot. And if he's elected, it can't remove him from the Electoral College. It can't remove that Electoral College from its vote being certified in Congress, which is even more so now because of democratic reforms that they have passed that make it even harder to bring such contests. And then the question is, can a state just lock up the president of the United States, the elected president? It has always been assumed that the answer is no, but this case will now test that. And so that will be one of the big issues. They will likely bring motions to stay the proceedings if they're smart. I do not have confidence in Trump's current criminal defense team. I do not understand why he doesn't have Alan Dershowitz be the lead lawyer on his team. I had an hour-long discussion with Alan Dershowitz on the Alex Jones show on Friday about this case. People can find it at band.video, appropriately named, of course. And it was a good, productive conversation. It's clear Dershowitz understands all the issues here. Dershowitz is one of the very few lawyers in America who has won criminal jury acquittals, has won criminal appellate reversals, has won major constitutional cases, has won high-profile cases, has won politically hot cases, has won cases against the odds. That's exactly what this case is. And he's a liberal Democrat licensed in New York. So why you have sort of a guy who Trump's own team is leaking is kind of a dumb loudmouth who had been on Democratic media over and over again, who suggested, by the way, that this somehow was a crime years ago when he was yipping away as a mouthpiece for liberal Democratic media. Why Trump has this idiot as his lead lawyer is beyond me. So Trump needs to improve the quality of his defense team quickly. His own members of his entourage are leaking this like a sieve to the press because they know Trump reads media. It's the easiest way to reach him sometimes is through the front pages of a newspaper. He could improve in that regard, too, not have that be the main means to reach him. But he has a lawyer represented Kimberly Guilfoyle and A-Rod and other people. I've seen nothing from the guy that suggests he's the lawyer for this case and seen plenty that he's not. But one of the things that should be brought is a motion to stay all proceedings on constitutional grounds because he's a former president and the leading opponent in the campaign, and that the case should be stayed until the election for presidency is resolved. And if he is elected, that it should be stayed until he's out of the presidency. There's still a problem, which is if state prosecutors can weaponize their prosecutorial offices to threaten imprisonment for presidents, then or leading presidential candidates, then they can effectively control presidential policy through the extortionate risk present in that. And that's a major problem. The question is whether the courts of New York are capable of stepping up to the table and answering this question, or the Supreme Court of the United States, which is going to have to get involved in this case sooner or later. Now,
people are asking, but hold on, what is Trump being charged with? They said the indictment could include up to 30 charges. They've announced an indictment, and as far as I know, we have not seen the actual indictment and the charges brought.
We have not. The fact of the indictment was leaked. The knowledge that he would be arrested or processed on Tuesday was released, but the CNN claimed there were 34 business fraud charges. The assumption is that these all relate to the Stormy Daniels matter in some way, but it's possible that they reached out to other areas. Based on who they were inquiring with the grand jury, that would come as a surprise because it appeared that Professor Turley, Jonathan Turley's approach, another liberal Democrat very critical of these proceedings, has said that, that he thinks they've just multiplied the same thing and just tagged on 34 charges to the classic case of over-prosecution. But it did mislead people. I mean, there were people who thought he's being charged with serious business fraud. And that may be the media narrative objective with the structure of the indictment is to avoid the fact that it appears really just to be a Stormy Daniels connected case. The next question will be the arrest proceedings. Will Trump be processed? Will they put Trump in jail? Will they try to perp walk Trump? Will they try to publicize the proceedings with video or photography? There apparently is already concern in the New York Police Department that they see this case as openly and overtly political, that they don't see a factual basis for it, that they see it as an abuse of prosecutorial power, an abuse of their offices. So they will likely want these proceedings to go the way that they did for my client, Amy Cooper, the so-called misidentified, in my view, Central Park Karen. In that case, they negotiated so that there was no perp walk of any kind. There was no visit to a jail of any kind. The processing took place outside of the media purview. There was no risk to her well-being by putting her anywhere near a jail. And the processing took place, and she ultimately only appeared by video, never in person in court ever. So we're going to find out pretty quickly whether the prosecutors and the courts are going to do this in a manner that's respectful of the president's position, or whether they're going to continue to use this as show theater right out of the gate. Are they going to abuse their arrest power for politicized purposes? Now, the Secret Service defends the president. They will help negotiate this because they have already made clear it would be a risk to his safety to do anything other than how they recommend the processing work. Again, there's no training on this for the Secret Service because it's never happened before. In fact, no one has even seriously considered it before, not even in the case of Nixon. Nixon was only pardoned on federal charges. He could have been charged on state charges. Nobody thought of, hey, let's go ahead and prosecute him anyway. That was seen as insane and dangerous to the country and constitutionally dubious. But that'll be the first part. The next part will be, will bail power be misused by the judge? This judge is a political hack who has already expressed continuous bias, not only in favor of the prosecutor's office in general, but a former prosecutor and lifelong government lawyer himself, but a very anti-Trump bias. As Professor Dershowitz noted, that there's every judge in New York knows that the political power is on the Democratic anti-Trump side of the aisle in Manhattan, a 90+% Democratic voting area, and it is highly unlikely he can get an impartial judge or impartial jury. This particular judge has already expressed bias against Trump in multiple proceedings. In fact, it appears to me his assignment does not appear random. So already the New York judiciary is failing its test of impartiality. The process is supposed to ensure a randomly assigned judge. This may have been manipulated by the prosecutor. They did this in the Roger Stone case. So what they do is they say that a case is a related case to get a particular judge that they want. This is how Roger Stone got assigned to the same judge who had already, Amy Berman Jackson, who had already expressed bias and prejudice against Paul Manafort, was the feds manipulated to get her assigned the Roger Stone case. And so will bail somehow be denied? Will the court issue some ridiculous bail order? Will the court try to jail Trump? Will the court try to restrain his travel? Will the court try to restrain
or his social media content, like they did with the Canadian prisoners? They can't post to social media, nothing to truth. Can't. Who knows? Oh, sorry. Go on, Robert.
Exactly. So there's constitutional restraints on bail. The 8th Amendment to the United States Constitution is enforceable through the 14th Amendment against the states, and the states have their own comparable constitutional requirements of bail. New York, of course, notoriously now has liberal bail rules that are supposed to promote early release and quick release, not detention. They're letting accused murderers and accused rapists out on a regular basis, accused stalkers out on a regular basis. It would be an egregious abuse of and an unconstitutional abuse of power if this judge tries to weaponize bail to either prevent the president's travel, to try to lock the president up, to try to require a massive cash bail, to try to seize funds and assets of the president, to try to limit his travel, to try to limit his social media access, or, as is being popularly discussed, an attempted gag order, which would be prior restraint in violation of the First Amendment. Generally speaking, gag orders in the criminal context are unconstitutional, whether it's applied to the lawyer or applied to the defendant. It has to be very narrowly tailored, and they have to show a compelling public interest. So, for example, you can sometimes, on the eve of a jury trial, restrain what someone can say that won't come into evidence at the trial. That's the very limited scope in which higher courts have allowed gag orders. Otherwise, they're just flat out unconstitutional. So if this judge attempts to do that, it will show, again, this judge's incapacity to be impartial. It will show the political prejudice and persecutorial tendencies of this prosecution if they even request such a gag order. It'll be a First Amendment violation. I'm sure the president will take it up on appeal immediately, all the way up to the Supreme Court of the United States. And it's the kind of case the Supreme Court is likely to take. Because if by merely charging someone, you can prevent your political opponent from campaigning, then that would be a serious problem. The president's already announced he's going to speak on Tuesday night at Mar-a-Lago after the event, so he anticipates, clear release. There may be efforts to try to restrict what he can say in those proceedings about the prosecutor, about the judge, or about this case. That, too, would be a First Amendment violation. So the judge can try a gag order. It can be temporarily enforceable, but it's not constitutionally enforceable. And I anticipate it would be set aside if the judge does it. Now, after that, go ahead.
I was just going to ask state charges. So even if Trump ever becomes president, he couldn't pardon himself for these charges at any point.
That's correct. That's part of the constitutional problem with these. It's one of the issues. If any local prosecutor can remove a political opponent with just prosecuting him, indicting them, then do we have a federal system of governance anymore? We really don't. I mean, it's something the court has sat on the sidelines with because of the politics of the Nixon case. They I think mishandled the Nixon case. They really didn't deal with what are the flow through consequences of this. Same with the Clinton versus Jones case. They really didn't go through, okay, what's exactly the consequences of allowing a civil suit to proceed against a president? And there's problems there that they never fully addressed or answered. This case poses those problems in clear relief. And depending on how egregious the abuse of power is by the New York courts, will detail how much these issues get meaningfully addressed. Now, as Alan Dershowitz noted, probably the other than a motion to stay, which would probably be maybe the second motion brought, the first motion that should be brought, aside from making sure there's no gag order, no unconstitutional restrictions or restraints on bail, is a motion to transfer venue. It's a case. Now, there they should do detailed polling, which it won't be hard for the polling to prove. You can even find a liberal Democratic pollster, a Stanley Greenberg type, to do it. Will show without question that Manhattan is a place that is contaminated with so much Trump hatred, it is impossible to get an impartial verdict. And move the case right within New York, one of two places. You could move it upstate, by the way, which is what's happened in many police shooting cases in New York, famously in the 41 shots case. Or just move it over to Staten Island, where the area is split and where you can actually get a impartial jury. That should be the first motion brought, and that's a motion that under select circumstances you can appeal, and at a minimum preserve your future rights that its denial would set aside any adverse verdict. Then you have motions to dismiss. The motions to dismiss could first be brought on statutory grounds, namely the statute of limitations prohibits the charge. They're going to try to argue, based on bad New York law, that being outside of the state tolls the statute of limitations. That makes no sense. The statute of limitations is there and only supposed to be told when the prosecution can't indict. There's no question they could indict. Right? They didn't need the presence of the president, and they could have always secured the president's presence of him throughout that entire time frame. They knew where he was. He was in the White House. So unlike it was hidden where he was. Frequently in New York, by the way, during that time frame. Didn't change residency until a couple of years into his presidency. So but there's motion to dismiss for statute of limitations. Secondly, a motion to dismiss on constitutional grounds, that if the statute can be so broadly interpreted that it could reach this conduct that deprives the president of fair notice, and the rule of lenity requires that due process of law dismiss the indictment as being void for vagueness, as being overly broad, as failing to put anyone on fair notice. Michael Tracy and others on the left have noted, if suddenly any non-disclosure order payment is now hush money, and hush money is now a crime, if not disclosed as such on government documents, as Dershowitz noted, no non-disclosure agreement its underlying confidential information is disclosed on corporate documents. This makes every non-disclosure agreement's actual legal enforcement by a business or individual a crime in the state of New York.
It basically turns settlement agreements potentially into crimes. Settlement agreements are, we want no one to know about it. It's a resolution of a dispute amicably, and you can't talk about it. Criminalizing peaceful resolutions of disputes, it's beautiful.
Then I think there's additional grounds to dismiss. If the statute of limitations can be interpreted in this vague way, then it's a violation of the Constitution. If a state has the power to derail a political opponent in this manner for the presidency of the United States, then I believe it violates the separation of powers that is established between the federal and state governments under the Constitution, though a motion to stay would achieve the same objective. And there may be additional motions to dismiss based on probable perjury before the grand jury, probable misinterpretation of the law to the grand jury. Both of those are grand jury conduct that is enforceable through dismissal. They can preserve the right to claim that exculpatory evidence not presented is such. Right now, the Supreme Court has said that's not a violation of the grand jury clause, but that was over a very controversial split decision that should be preserved by challenging it and contesting it here. Then you have motions for discovery. that can take place as to what really took place throughout the proceedings. Was the grand jury an impartial grand jury? What was presented to the grand jury? What other evidence exists that exculpates? Again, internal memorandum will probably show that the New York prosecutor's office previously determined this was not a legitimate prosecution, that there was not a factual or legal basis to do so. Motions to dismiss on selective prosecution grounds in violation of the First and 14th Amendment. Easy to show here because the prosecutor, first of all, publicly stated he was going to indict Trump as part of his election platform. Secondly, other prosecutors refused to prosecute both the New York DA's office and the Southern District of New York on grounds that it would be selective prosecution. Third, there's no analogous case that has ever been brought in the history of New York on these factual grounds. No historical example of it being brought against a political opponent on these grounds. No historical example of it being brought against a former president on these grounds. If this isn't selective prosecution, I don't know what is. He and his wife and the other prosecutors involved have stated on social media their intention to basically do a Berea-style prosecution. Show me the man, and I'll find you the crime. If this case doesn't violate selective prosecution, then no case violates selective prosecution. The courts have gone wayward at enforcing that. This case presents a perfect opportunity for them to re-examine that law and meaningfully enforce the First Amendment rights against selective prosecution. In terms of the timing of the case, and obviously this would be a very important jury selection case in terms of voir dire, written jury select, written questionnaires, meaningful inquiries into areas of prejudice and bias. Trump needs to have the best jury preparation, jury trial team, jury selection team available to him and not gamble on that side of the aisle if he is stuck with a jury trial in Manhattan. But in terms of the timing of the case, Dershowitz agreed with me that it is unlikely to be tried before until we're right in the middle of the elections. And if the court is conscientious, it will postpone any trial until after the election. But we'll find out very quickly whether this court is conscientious or just another political hack on the court. And so it will be, this is an extraordinary case presenting extraordinary risk, but it will present also extraordinary opportunity for the American people to be educated on the deep problems in our criminal justice process that will be exposed once again by this wayward rogue prosecution of the president, who President Trump is constitutionally innocent, legally innocent, and factually innocent. He's constitutionally innocent because this is selective prosecution, violation of the constitutional principles in a law that's being over-applied and a statute of limitations that's not being applied, to which he had a fair notice right to be enforced. Second, he's legally innocent because what they're going to describe is not a crime, because if settlement agreements are a crime, then everybody belongs in prison that's ever done one. If non-disclosure agreements are a crime, 90% of businessmen and celebrities now belong in federal prison. If funding your own campaign is a crime, then that violates the First Amendment by itself. And then he's factually innocent because the only witness that we know of testifying against him is an admitted perjurer, an admitted fraudster, who's now being sued by Alan Dershowitz for defaming and libeling him just 2 days ago. So this is a disbarred, discredited, disreputable lawyer who has a long history of fraud, corruption, and deception, whose own public statements by his own counsel who he released to make these statements directly contradicts the sworn testimony apparently now before the grand jury. And this is the only witness they have to testify as to the substantive merits of the case against Trump. So Trump is constitutionally innocent, legally innocent, factually innocent. It is a dangerous, perilous case that has crossed a Rubicon of American constitutional law, but it's an opportunity for more American people to be educated about the problems in our criminal justice process, for Americans to rally to Trump support and the defense of the Constitution, and hopefully in the end, there will. My prediction: Donald Trump won't serve a single day in jail for this utter nonsense. But a lot of deep state, complicit, corrupt actors that are responsible for this will suffer political and, I believe, ultimately legal consequences down the road.